Welcome to today's presentation, COVID-19 Interest Abatement, Kwong, Abdo, and Section 7508A. We appreciate you joining us today. We're going to allow a few seconds to allow everybody to come in. But before we begin, we have a few housekeeping rules. Please take note of the CLE for your records. Today's course is approved for credit, and the CLE course number is 9717. We'll repeat this code again at the conclusion of the presentation. We will also be putting the materials in the group chat. We encourage an interactive session. If you have any questions regarding the CLE, please submit them using the Q&A box on your screen. We will monitor these throughout the session and address as many as possible during our dedicated Q&A segments. We also want to highlight some important upcoming CLE opportunities. We have charitable organizations, an update on Florida's solicitation funds process, and the Honest Services Registry by Richard Kwong from Jones Foster on April 29th at the end of this month. We also have the 2026 annual meeting in Key Biscayne, Florida on May 14th through 16th. There's going to be a CLE focus on state and local taxes. Please make sure to register for that one. Today we have our speakers, Gray Proctor and Andy Steigleder from Kostelanetz. I'm so sorry, maybe I may have pronounced it incorrectly. They're both experienced attorneys who practice at the law firm Kostelanetz. They frequently collaborate on complex federal tax controversy and appellate litigation matters. Andrew and Gray, I'm turning it over to you. I'll be turning the slides.
Okay, well, thank you very much, Andrea. Good morning, everybody. I'm Gray Proctor, and I'm counsel at Kostelanetz LLP. And then joining me today is Andy Steigleder from our Atlanta office. Thanks, everybody, for joining us today. Our topic today is COVID-19 penalty and interest relief under Section 7508A of the Internal Revenue Code. If you practice in tax controversy, this is potentially one of the most consequential developments of the last decade. And the clock is running. The outer boundary for most of the administrative refund claims is July 10th, 2026, which is just a few months from now. So our goal today is to give you the legal foundation, the practical tools, and the urgency to act for your clients before that window closes. And we'll start with introductions. Next slide, please, Andrea. Andy's a partner in our Atlanta office. His background spans tax law, accounting, finance, and securities. And before joining Kostelanetz, he was a principal at Ernst & Young, leading the tax policy and controversy for the Central Region. And before that, he was a partner at Meyer Brown for 13 years. We know Andy for a lot of things in the Atlanta office, but the number one thing we call him is our valuation guru. He draws on a deep, deep vein of expertise valuing real estate, business interests, and tax benefits. And on the back half of this presentation, he's going to have a lot to say about how to extract the most value from this opportunity for your clients while still complying with Circular 230. He brings a unique blend of planning and controversy experience that's directly relevant to the valuation and computation issues we're going to discuss today. Andy, what did I leave out?
No, I think that's great. Gray, thank you for the introduction. It's a pleasure to be here. Although I'm based in our Atlanta office, I am in Florida this week. So it's a great opportunity to present here. And this is a very, very significant development. I've done tax shelter litigation and everything related to shelters for the last 23 plus years. And with big controversies and even on either scale or scope, comes issues with penalties and interest. And this is directly relevant to what we're doing today because unwinding, computing, determining what's ultimately owed is a very tricky part of the tax controversy landscape. And here we have a very unique opportunity that impacts potentially, millions and millions of taxpayers that practitioners, one, should understand, and two, be ready to proceed under the deadlines that we have here, July. So I think this is a very, very good opportunity, and I think we're in a very, in terms of practitioners, in a very unique space right now where it's holding the IRS to their own rules and collecting money for our clients that otherwise under previous rules would not exist. And so Looking forward to this. Gray, if you could then, I guess, take over a little bit of your background and let them know what they'll be hearing about today.
Okay, thanks, Andy. Yeah, I'll take it off. And if next slide, thank you, Andrea. Thanks, Andy. So I'm an appellate attorney. I'm board certified in appellate practice in Florida. At Kostelanetz, I take on an issues and appeals role. My practice covers the full arc of tax controversies, from preserving the issues in tax court to briefing and arguing in the circuit courts and the Supreme Court. This issue is a perfect example of why appellate thinking matters at every stage, because you've got to frame your 843 claim correctly so that you can raise the arguments on appeal 2 years from now if this is still an issue. I'm also active in Florida in the 11th Circuit in appeals in constitutional law, commercial law, insurance coverage, condominium, and all other kinds of sunshine state areas of law. So next slide, please. And this is what we will be covering today. And here's the big picture. We have two very recent federal court decisions, Kwong in the Court of Federal Claims and Abdo versus Commissioner in the Tax Court, that show us that the IRS should not be charging failure to pay or failure to file penalties or underpayment interest during the entire declared COVID-19 emergency, which ran from January 20th, 2020 through July 10, 2023. Now, these cases also strike down portions of the regulations that Treasury put out there to try to limit the effect of the literal text of the statute. Abdo is particularly interesting here because it predates Loper-Bright, meaning that the regulations couldn't even pass muster under Chevron. So in addition to covering the legal basis for those claims for relief, we're also going to get into the practical implications for your client's interest and penalty liabilities and the step-by-step procedures to raise and preserve these claims, including how to use AI tools to compute the amounts efficiently. For those of you who are chomping at the bit to get to the AI section, if you're interested in the details of the specific prompts that you can use, reach out to us. Frank Agostino, who has been at Kostelanetz since the past year, and he's a tax bar legend. One of the many, many things Frank does is run a low-income taxpayer clinic called the Taxpayer Assistance Corporation. And he's put out a series of articles that are an invaluable resource. We're happy to make them available to you. Next slide, please. And what we're going to learn today, first, we want you to understand the historical background of the disregarding periods, because the legislative history and the language Congress is using throughout are central to the legal basis. Second, you need to understand Treasury's failed attempt to regulate away the plain text of Statute 7508. These regulations were invalidated in Abdo and Kwong, and there are some non-retroactive, amendments that Congress passed in 2021 and 2025 that confirm the broad scope of the 2019 version that applies to COVID. Then we'll cover how to raise these claims administratively in a Form 843 or in collection due process proceedings and in litigation. And finally, we'll walk through how to calculate these recoverable amounts, potentially using AI-assisted computation workflow. Next slide, please. So with that out of the way, let's move into the substantive material. Next slide, please. We'll start with this concept of disregarding periods, and particularly for service members. And this idea goes back in tax law to World War II. In 1942, we have Congress enacting Section 3804 of the Internal Revenue Code, and it provides relief to service members who are deployed overseas. It's a simple, humane idea. If you're fighting a war abroad, we're not going to hold it against you that you missed a tax deadline. And that's that. To get more specific, the statute provides that any period during which an individual was outside of the Americas for 90 days would be disregarded for the purposes of determining whether the following acts were performed on time: filing any return, income, estate, or gift tax, paying any income, gift, or estate tax, filing a petition with the Board of Tax Appeals, today that's the tax court, of course, and allowance of a credit or refund of any tax. So next slide, please. Now, after World War II, Section 3804 is recodified where it lives today in Section 7508. And it's amended slightly, but it still basically covers service members. And the key language of 7508 is the same as it was before. During the relevant period, the running of any period of limitations on filing returns is disregarded. The same thing for the time periods for filing refund claims, paying taxes, filing tax court petitions. All of it shall be disregarded. Now, here's the question. Just looking at this, here's the question I want you to hold in your minds. If the IRS is told to disregard the period for paying taxes, isn't that the same thing as interest, right? If you're disregarding the period for paying your taxes, that means interest. And it also means the failure to file and failure to pay penalties. Next slide. So 7508A bridges the gap from service members to anyone who is affected by a federally declared disaster. 7508A mostly works by cross-referencing what's going on in 7508. Next slide. So this timeline shows you the statutory evolution. There on the left side, you see the original framework with Section 3804 in 1942, and then 7508 in 1954. And then in 1997, Congress enacts 7508A, and that's what extends the concept of a disregarded period to federally declared disasters. One important qualifier here is that originally this is discretionary relief. It allows the secretary to specify a period for up to 1 year that may be disregarded. But in November 2019, that's in the middle here, Congress adds subsection D, and this is a game changer. Subsection D makes the relief mandatory and self-executed. And the gist of it is, it says that the period from the earliest incident date, the declared emergency, through 60 days after the latest incident date, so it covers the entire emergency, shall be disregarded in the same manner as a period specified under subsection A. No IRS notice required, no secretary's determination, automatic. The purple entries on the right side are the post-COVID amendments, and we'll do them in later, but just be aware that the statute has now been changed. To the extent this was a loophole that allowed for a really long period of disregarded period, it's been closed. Next slide, please. So to start, let's go through the key language of subsection A, because the interplay between subsection A and then 7508 itself and then 7508D, that's where the legal argument lives. The heading here says A1. That's often the focus because it's complicated, but as you'll see, subsection A2 and A3 are important as well. So starting with subsection A1, the secretary may specify a period of up to 1 year that may be disregarded in determining 3 things. First, the specified acts in 7508. What are these again? Filing any return, paying any tax, filing a petition with the tax court, allowing a credit, filing a claim for credit, and bringing suit upon any such claim or credit. So it extends everything. Second, the amount of any interest, penalty, additional amount, or addition to tax for periods after the disaster date. And then third, the amount of any credit or refund. This operates in connection with the look-back problem. We'll do a little more detail in that later, but especially in connection with the new 7508AF, This lets the taxpayer receive the full amount of the refund, notwithstanding that 3-year cap that's in section 6511 B2A. If we only had a disregarded period for bringing the refund suit, the taxpayer could bring the suit, but then they wouldn't be getting the full amount of the refund. So subsection A has always covered penalties and interest. It's not limited. The secretary had a lot of discretionary authority, and that matters because of how subsection D incorporates subsection A. Next slide, please. All right. Here's the text of subsection D1. So it says, for any qualified taxpayer, the period beginning on the earliest incident date and ending 60 days after the latest incident date shall be disregarded in the same manner as a period specified under subsection A. So I do this for a living. I find this to be tricky language personally. And what's tricky about it to me is a period specified under subsection A. What does that mean? Does that mean a period where the secretary has exercised his discretionary authority? Or does it not? Are we left with a regime where the secretary has to do something in order to get this mandatory relief? So I'm going to spoil the answer for you. This is not an open question today. The tax court's going to hold 12-0 that this language is unambiguously self-executing, and it doesn't require or even permit the IRS to do anything. Second, we have the phrase in the same manner as a period specified under subsection A. I mentioned that, but that's subsection A2 as well. So it's incorporating all 3 categories of relief. And so there's the specific cross-reference to deadlines, interest, penalties, credits, and refunds, aside from just the cross-reference to 7508. So this is where we are in 2019. And at this point, we'd recently had, not recently, but within the past 20 years, we'd had Katrina with an incident period of 64 days. That's an example of a long one. We'd had Kilauea in Hawaii. That's about a 5-month incident period. And there was a really long Kilauea one in the 90s as well. Flint, Michigan is 2.3 years. And then we have the 1994 earthquake in California at 317 days. Those are our longest emergency periods. And then we also have 5 declared disasters that are in the 200-day range. And that's where we are. Next slide, please. When we get to COVID-19. So COVID happened not only for a long time, but over the entire United States. So you look at this, you look at the results, and you look at the potential financial impact, and I think you might say, yikes, right? Well, the IRS says yikes. You'll see how Treasury tries to save us from the statutory language with what's basically a regulatory rewrite, but it's going to lose, and it loses before Loper Bright, just to give you an idea of how far off base these regulations are compared to the statute. Let's hit slide 14, please. Next. This is a chronology that lets you see how Congress reacts to COVID-19. In March 13, 2020, we have the nationwide emergency declaration. In January 13th, we have regulations, which we're going to get to on the next slide. In November 2021, Congress takes action prompted by the COVID to limit mandatory disregarding periods to 60 days. And then later on in July of 2025, that's extended to 120 days. And then at the end of 2025, in December, we have another provision that extends the Section 6511 look-back period. It categorizes the disregarded period as an extension, and that's important due to the phrasing of the 6511 look-back period. Next slide, please. But let's take a look now at what Treasury did and why it failed. Treasury issues regulations that attempt to rewrite the statute in two ways. The first is Section 301.7508A 1G1 and 2. It limits the time-sensitive acts that are postponed or the period for them is disregarded. Only the acts that the Secretary has already chosen to postpone through his discretionary authority. So the regulation says that the mandatory provision in subsection D only kicks in after the Secretary exercises discretion under subsection A. That collapses the mandatory into the discretionary, and it, in my opinion, reads the word shall out of the statute. But second, paragraph G32 of the same regulation caps the mandatory disaster period at 1 year, regardless of how long the federally declared disaster actually lasts. For COVID, it's over 3 years, and under the regulation, 1 year is the limit. So, one other thing to note is that in the preamble to this proposed rule, Treasury explicitly says, and I'm quoting here, Section 7508A is not self-executing, end quote. Treasury, again, very explicitly says nothing happens here unless Treasury does something. So how do these regulations hold up in court? Next slide, please. We'll look at two cases in a little bit of detail. First is the Abdo case. In this case, Mohammed Abdo and Fardowza Farah received a notice of deficiency dated December 2nd, 2019. And so that gave them until March 2nd, 2020 to petition the tax court. They mailed their petition on March 17th, 2020, 15 days late, and the IRS moves to dismiss. The question here is straightforward. Does Section 7508A(d) extend the deadline? The IRS says no, because the regulation limits everything to whatever the Secretary decides. And next slide, please. The tax court rejects this position unanimously in a full reviewed opinion with 0 dissents. And the key holdings are that on the basis of the plain and literal language of the statute, Congress clearly intended to provide a mandatory period. So that means that subsection G1 and 2 are invalid to the extent they condition mandatory relief on the Secretary's prior exercise of discretion. One important thing about Abdo, the case settled without any kind of appeal in 2024. So that means right now, Abdo is final binding authority in the tax court. Next slide, please. So now to move on to Kwong. This is the Court of Federal Claims case, and it was decided in November 2025. The posture here is the Court of Federal Claims making a ruling on a motion for summary judgment. So this case isn't completed yet, and we haven't seen any appellate action here yet. Obviously, we expect to. But to get to the nuts and bolts of it, Mr. Kwong files a refund suit in February 2023. 2 of his refund claims had been denied in September and October of 2020, meaning that under the normal 6 months limitations period, they're facially untimely, and the DOJ moves for summary judgment. And this is unusual. Sua sponte, the court orders supplemental briefing on the impact of 7508A. So the court has identified this issue before the parties have fully briefed it. Next slide, please. The Kwong Court's key holdings go a little further than Abdo in several respects. First, the court confirmed the disaster period. The government tries to argue that the declaration only covered January 20th, 2020 as a single date, but the court rejects that. The declaration says beginning on January 20th, 2020 and continuing. Second, the court held that the mandatory postponement applies regardless of the 1-year cap in Treasury Regulation 301, subsection G3 2. The court acknowledges that Congress may not have anticipated a disaster that lasts over 3 years, but it says that the statute's express text nevertheless applies. Here, they're determining congressional intent by the words Congress enacted, not by the situations that Congress might have imagined. And once again, on a procedural note, there's been no final judgment here, and the government is widely expected to appeal, but the statutory argument is strong. And so let's go on to the next slide, please. Okay, so those are the cases. What can you do with them? There looks to be a lot. Today, we're not going to have time to touch on everything, and we're going to focus mostly on the lens of refund claims and the different components of calculating the amount due. Next slide, please. So first and most straightforward, interest on underpayments. If you have a client that owes interest on underpayments, the disaster period should be disregarded, and the interest should not accrue on underpayments starting January and ending July 10th, 2023, starting January of 2020, of course. So for a taxpayer who owes $100,000 in unpaid tax, 39 months of interest at those rates is probably somewhere in the $15,000 to $20,000 range, if not more. A second question is, what about the tax liabilities that became due before January 20th, 2020? The regulation 301.705-7508A-1F, there's an example in there that says a taxpayer would not be entitled to any benefit, but that regulation rests on the same interpretive framework that Abdo and Kwong rejected, the one that puts the Treasury in charge of basically everything. And I don't think it's supported in the statute. And besides that lack of any textual hook, think back to the origin of the statute and think back to why we have it and what it first was. It was for our service members. What 75088 does is to give the average taxpayer in a disaster zone the same benefits as a soldier who's deployed. Do we want our soldiers worrying about how to pay their rapidly accruing tax bill while they're deployed? So keep that in mind for anyone advocating. Next slide, please. Next slide is additions to tax. Failure to file and failure to pay. For tax years whose original due dates is within this disaster period, mostly 2019 through 2022, the late filing and late payment penalties should be abated for every month that falls within the disaster window. This is fairly conservative. It's more or less a direct application of the holdings of Abdo and Kwong. Otherwise, these penalties accrue monthly. Failure to file at 5% per month, capped at 25%. Failure to pay at 0.5% per month, also capped at 25%. Section 6651C1 reduces the failure to file rate by the failure to pay rate, so the combined monthly ceiling is 5%. They accrue month by month here. So every month within the disaster window should be excluded from these calculations. Now, Kwong and Abdo didn't get into the question that the regulation purports to answer, whether we include penalties on tax years whose due dates preceded the disaster. Expect a fight here. The IRM says those penalties continue accruing, but again, still relying on the old regulations. And another practice note here, notice 2022-36 automatically abated failure to file penalties for 2019 and 2020 returns filed by September 30th, 2022. So check your taxpayer transcripts to see if you've already gotten that kind of relief. Let's go to the next slide, please. Now, overpayment interest is the mirror image of underpayment. And this argument is made possible by another cross-reference to 7508. Specifically, Section 7508C incorporates the rules of Section 7508B, which in turn switches off the provisions that ordinarily prevent taxpayers from getting interest on overpayments that they make. The IRS's own IRM Section 20.2.4.8.3.4 acknowledges that the IRS is required by law to pay interest on overpayments during these disaster postponements. In terms of current events, this has already generated class action litigation. Fleschers versus United States has been filed in the Southern District of New York, seeking overpayment interest for the full disaster period. And on its own behalf, Western Digital has filed a claim in the Court of Federal Claims involving $21 million in pandemic era interest. Next slide, please. Now, an area that gets interesting and consequential is the question of whether 7508A operates as a tolling provision or merely a postponement. This is lurking in the background of deadline calculations in many ways. But the IRS's position is that 7508A only postpones deadlines that would otherwise fall within the disaster period. So if your deadline would have expired on, say, April 15th, 2021, the new deadline is July 10th, 2023. And if your deadline was April 15th, before the disaster in 2019, it's already expired. Taxpayers here, your position is that 7508 suspends the running of all limitations period for the durations of the disaster. This is the tolling reading. And under this view, the clock stops on January 20th, 2020, does not run during the disaster, and starts running again on July 11th, 2023, picking up wherever it left off. The Supreme Court addressed the meaning of tolling in Artis versus District of Columbia. So if you're interested in this topic, ARTIS versus District of Columbia, it held that tolled means the limitations period is suspended. The difference is enormous here. Under postponement, you only benefit if your deadline happens to fall within the window. Under tolling, everybody with a running limitations period gets the full benefit of the 3-year plus suspension. Next slide, please. Just to walk you through a concrete example here and illustrate the stakes. Suppose a taxpayer files her 2020 Form 1040 on April 15th, 2021 and paid the reported tax. She later discovers that she overpaid. Can she timely file a refund claim today? Under the postponement theory, no. Her 3-year deadline did not fall within the disaster period. It would have expired on April 15th, 2024, and that's too late. Under the tolling theory, potentially yes. If the 3-year period was tolled from April 15th, 2021 through July 10th, 2023, it didn't begin running again until July 10th, 2023, which gives her until approximately July 10th, 2026. Something else that adds another layer of complexity, because that's what we all need in our lives, are the refund look-back rules here. The answer looks good, though. Public Law 119-64, that's in December 26th, 2025, adds what we have now as Section 7508AF, which provides that the disregarded period is treated as an extension of time for the purposes of the 6511 look-back. 6511B2A separately limits the amount you can recover, measured backward from the date you filed the claim, to 3 years plus the period of any extension of time for filing the return. So this is something else to be sensitive to as you walk through these claims for your own clients, which now Andy is going to jump in and tell you a little bit about how to do that. Before I say one last thing, I want to mention Frank Agostino one more time. He's published his articles through the Taxpayer Assistance Corporation, which is his low-income taxpayer clinic. Not only do they hit every angle, but they can show you more precisely than we can today how to get your software to calculate absolutely everything. Frank will be doing a seminar on this on April 21st. The in-person portion is limited to 25. So if you're in Hackensack and you want to attend, act now. Otherwise, email him or one of us and tell us you're at the CLE and you want to know more, and we're happy to arrange it for you. And with that, Andy?
Okay, thank you, Gray. And again, I stress this. If you just Google Taxpayer Assistance Corporation, they have a Journal of Tax Controversy, and Frank Agostino has published an article. It's effectively a guide called Minimizing Pandemic-Era Tax Interest and Penalties, a comprehensive how-to guide. I'll discuss that in my presentation today, but if you want to email us, email Frank, look for it online. We can get you a copy. It is an excellent, excellent resource that practitioners have. And the point here is that practitioners need to be aware, need to do this. We spent the first half, just to level set. If we go to the next slide, please. Okay. And we spent the first half of the presentation kind of laying out the legal architecture, the history of the disregarding periods, the statutory text of Section 7508 Cap A, and obviously the landmark decisions in Abdo and Kwong. Now we're going to pivot to the part that matters most to you and your clients. All right, what do we actually do with all this? How do we turn these legal victories, what we appear to be victories, into dollars back in your clients' pockets or balances removed from their accounts, right? Refunds or abatements. And again, I want to be very direct about something before we continue. The window to act is closing. That's why we're telling you about the guide. That's why we're having this conversation now. For most tax years, 2019 through 2021, the critical filing deadline for administrative claims is, if everyone doesn't have this burned in their memory, it's July 10th, 2026. Okay, that's a little over 3 months away, and taxpayers and their advisors must act fast to preserve their claims. If you wait, the statute of limitations may foreclose your rights entirely, and there's no amount of favorable case law that will bring them back. I will also add this: the Taxpayer Advocate Service is aware of this issue. This is a percolating issue and one that will continue to grow, and we hope it continues to grow. They recognize that the IRS's automated systems assess penalties and interest during the disaster period without accounting for that mandatory suspension under Section 7508 Cap A. What we are seeing right now with practitioners beginning to file these claims, I believe, is just the tip of the iceberg, and it should just be the tip of the iceberg. The Taxpayer Advocate has flagged pandemic-era penalty and interest assessments as a systemic issue, and the volume of effective taxpayers no doubt runs into the millions. Every individual, corporation, and entity that had a filing or payment obligation fall within the disaster window from January 20th, 2020 through July 10th, 2023 is a potential claimant. Let's go to the next slide, please. All right, so we're going to start with who qualifies. Under Section 7508 Cap A D2, a qualified taxpayer includes any individual whose principal residence is located in a disaster area and any entity with a principal place of business in a disaster area. Here's a critical point. Every single state, every U.S. territory, and the District of Columbia received a COVID-19 major disaster declaration. Okay, that means that virtually every U.S. taxpayer qualifies. This is not a narrow group. So make sure you cast a broad net to assist as many impacted taxpayers as possible. In terms of covered tax types and years, we're talking about all federal income, estate, gift, employment, and excise taxes whose filing deadlines fell within that disaster period. That includes individual Form 1040, corporate Form 1120 returns, employment tax forms 941 and 940 for tax years 2019 through 2022. It applies to both delinquent returns that triggered failure to file penalties and unpaid balances that triggered failure to pay penalties and underpayment interest. And getting the request right is important. Okay, you need to distinguish between, this is the last bullet point, you need to distinguish between a refund claim and abatement request. If your client already paid the penalties and interest, you file Form 843 as a refund claim under Treasury Reg Section 301.6402-2B1. If the amounts are assessed but unpaid, you file Form 843 as an abatement request, and in a collection due process context, you raise it in Form 12153 at the CDP hearing. Getting this distinction wrong at the outset can and will create procedural headaches down the road. Finally, I'll mention Section 6662, accuracy-related penalties. There's a question here of when underpayment is calculated. Our position is that the penalty eligibility date crystallizes to July 10th, 2023. So if the taxpayer has filed and paid in full before that crystallized due date, there was no underpayment and therefore no penalty. This is kind of a logical inference from the statute, but no court has adopted it yet. So if you do include a Section 6662 claim, label it explicitly as protective in both the Form 843 and the cover letter. Again, be very transparent about the theory's novelty and what's going on here. And I would say filing a protective claim and asserting your rights under these authorities is ethically defensible under Circular 230. If we go to the next slide, please. Okay, so I want to walk through the mechanics of building your claim. This is really what you need to do to file these. Again, excellent resources that the TAC Pandemic Guide authored by Frank Agostino. I'm going to give you some basically high-level things here to help you to move forward. Step one, retrieve IRS account transcripts. You can file your Form 4506-T, checking box 8 for the record of account for each affected tax year. Okay, these transcripts become your evidentiary foundation, period. This is what you need, and you're looking for key transaction codes. TC-150 for the return filing, TC-160 and TC-170 for penalty assessments, TC-340 for interest assessments, and TC-610 and 670 for payments. These codes tell you exactly when penalties were assessed, what amounts were charged, and what the client paid. Without these transcripts, you're building your claim on sand. This is your basis you need to get started. And also, it's what you'll need when we discuss later some prompts to input into for your calculations. Step two of this is shown here. It's to identify the disaster window overlap. Okay, for each tax year, you need to determine the original due date, any extended due date, and whether the due date fell within the January 20th, 2020 through July 10th, 2023 assessment dates for penalty and interest. And then you look at the payment dates for the statute of limitation purposes. This mapping exercise is critical because the relief only applies to the portion of penalties and interest that accrues during the disaster period. So you have to define that. Step three, calculate your recoverable amounts. For underpayment interest, you use the IRS quarterly rates and apply the daily compounding formula under Section 6622 to compute the interest that accrued during the disaster window. You exclude interest accruing before January 20th, 2020 or after July 10th, 2023. For penalties, you identify all assessments during the disaster period. There's an AI prompt system that we'll discuss that Frank provides in his article that automates much of this calculation. And so again, I'm referring you back to that article. And I will say, just looking at the interest here, back in 2016, 2018, interest rates hovered around 3 to 5%. They trucked along at 3 to 4 for a long time, got up to about 5% at the end of 2019. Once you'd entered 2020 and really through 2023, you're dealing with 7 and 8% interest. All right, these are significant numbers. 3% interest, a lot of taxpayers have no issue running interest at 3%, paying to the government. You get to 7%, and these numbers are starting to balloon. 8%, it can be punitive effectively. So what we're doing is we're getting some relief for some very, very high interest periods. And what we're seeing is some very, very significant refunds and abatement requests for clients. I work in a large part in the conservation easement space. which was a very popular tax planning strategy for people located in Florida and the southeast United States. They're starting to receive bills from settlements. I can tell you the IRS is getting these bills wrong, and I can tell you with absolute conviction that they are not including these disaster suspension periods. Very simple analysis on these. Taxpayers can save. I mean, some of them it's at least 20% or more of their bills that are owed from years that fall under question. So this exercise is crucial for you to do, and these forms need to get them on filed, need to get them prepared. So we'll move then to the next slide. We've covered the first 3 steps of what we do for this 843. Now we're going into step 4, and that's submitting the form 843 itself. You have to file a separate form 843 for each effective tax period. And there's box 4 for interest and check box 5 for penalties applicable. And part 3 of that form, there's an explanation section. You just cite Kwong, Abdo v. Commissioner, section 7508A, cap AD, and the COVID-19 disaster period running from January 20th, 2020 through July 10th, 2023. Make sure you can put that in the form, and then you can have attachment. Your attachment, your cover letter, whatever it is, you should also include your IRS account transcripts, any copies of penalty notices, proof of payment, and effectively your deadline mapping worksheet. And you send everything by certified mail. Retain your proof of mailing. I can say this, IRS are getting things dramatically incorrect, losing filing. So it's not just enough to go through this process. It's enough to be able to prove that you have done it. So again, transcripts, proof of mailing, you are building your evidentiary case. Do not forget that. It's not enough to get the forms done. That Frank Agostino Tax Pandemic Guide provides sample cover letters and its appendices. You have Appendix A for underpayment interest and penalty refunds claim. Appendix B has overpayment interest claims. And these templates cite the specific legal authorities and lay out the factual basis in a format that the IRS should recognize. There's a reason we're kind of putting this out, because if they see enough of these, there's going to be power in numbers. And ultimately, our goal here is to force something to happen at a much higher level. And so, use these resources at your disposal, because again, the clock is ticking. You customize each one for your client's facts, which you get from the transcripts and all the information derived thereof. Step 5, diary and follow-up. Set calendar reminders at 30, 60, 120 days. Okay, the IRS is going to be slow on these. Anything you file, it's a near certainty, given the volume and the internal issues with the IRS, that issues are going to happen and delays will occur. So be warned, we are already seeing massive delays, inconsistencies, and outright errors in numerous IRS's notices and applications. So expect the same here. Okay, so this is the critical point. I want to emphasize, filing this Form 843 is just the beginning. We fully expect that many, if not most, of these claims will be denied at the initial processing level. The IRS systems are not configured to recognize the mandatory disaster period suspension for interest and penalties on this scale. Okay, so examiners processing these forms may not be familiar with Abdo and Kwong, and Treasury's invalidated regulations may still be baked into the IRS's internal guidance. So there's a lot to work through. Do not be discouraged by a denial. Assume it's an expected part of this process. The reason we need a broad base of taxpayers filing these claims is very strategic, right? The sheer volume of claims will force IRS management to address this on a global, systemic basis rather than case by case. And that's our end game here. And if only a handful of practitioners file, IRS can potentially bury this issue and hand it inconsistently. If thousands of claims arrive, which we hope they will, and potentially millions, and we stay coordinated, the IRS simply cannot bury this issue, and we will have power to make things happen at a higher level and ideally increase, more efficiencies and an efficient process for taxpayers and their advisors to get their refunds and abatements that they're entitled to. If we could go to slide 30, please. Next slide. So one of the practical challenges here is just going to be computation. And anyone dealt with interest netting in computations, right? There's a lot of nuance, a lot of precision that's required. And when you're dealing with daily compounding interest across multiple quarters over what we have here, a 41-month disaster period, the math can get complex pretty fast. So this is where we have found artificial intelligence tools can be enormously helpful. And that TAC pandemic guide that we mentioned, it includes a comprehensive master prompt. It's an Appendix E. All you need to do is cut it and paste it directly into an AI platform. I don't care if you use Perplexity, Claude, Accordance, BlueJ, whatever you have, and you can try it with different ones to see the outcomes. I used Harvey AI recently for one, and it worked perfectly. It is structured as a three-prompt workflow. Prompt 1 loads the legal framework into the AI before any math is done. So it hard codes basically the disaster dates, the quarterly rate table from the IRS, and the mandatory shall be disregarded standards. So it establishes the Kwong and Abdo framework as a computational baseline. Prompt 2 then walks the AI through a 7-step computational algorithm. It verifies qualified taxpayer status. It identifies that overlap period we talk about. It computes interest using the IRS quarterly compounding rates. It calculates the suspension benefit, comparing scenarios with and without the disaster disregard. It identifies penalty accruals within the disaster window. It computes the refund position and it outputs a structured summary with line item detail. These are all computations you can do. I'm suggesting look at that TAC pandemic guide and give it a test. Finally, they have a prompt 3. It drafts the Form 843 line 8 explanation. Okay, this is what you need itself. It has 5 required sections: identification, legal basis, which we talked about, computation summary, procedural history, and relief requested. If we go to the next slide. Okay, a few critical practice pointers on using AI for these claims. First, verify all output against the IRS transcript. You have to spot check at least one quarterly interest segment by hand or using the IRS factor tables in Revenue Procedure 9517. Remember, AI is a tool. It is not a substitute for professional judgment. Remember, it's your name on the Form 843, and you have ethical and professional obligations to your client and as a practitioner. Okay, there's a power and peril of AI. Remember to check your work for sanity and completeness. The dangers of having AI unchecked, I mean, we see them routinely. Just last week, I was in a major tax court case in Atlanta, Georgia, on a conservation easement matter with potentially billions of dollars at issue, over $1.1 billion. And one of the IRS's main experts, it became very clear when we were during the report and on cross-examination that he had used AI because there were some quotations direct quotations that didn't exist in his cited materials. There were quotations that were nowhere to be found in the reference sections. Okay, and this is someone who had chaired the Appraisal Institute Body of Knowledge Committee and the Professional Standards and Guidance Committee, and he worked on the International Valuation Standards Council Advisory Group. He's an author of many seminars and Appraisal Institute courses, publications, and he was an author and contributor to the Appraisal of Real Estate and the Dictionary of Real Estate Appraisal. So this is someone who was qualified to be an appraiser and a USPAP expert. But what happened is his use of AI completely discredited his report, and himself and the judge had grave concerns about his use of AI. And with that warning, the IRS counsel decided not to admit these expert reports. So let that just be a warning. Again, we're seeing more and more of these pop. If you're using AI, correct it. AI will save you a lot of time, but it'll cause a lot of headaches if you don't take the time to confirm your work. So how do we ensure reliability here? Let's go back up. We're not turning the slide yet. The second bullet point. Yeah, second bullet point. Use account transcripts as your primary data source. Look for those codes we mentioned earlier. 150, 160, 170, 340, 610, 670. Those are your keys. That's what AI needs to work with. That's the prompts we've created. And then finally, or third, I guess here, recognize that different AI platforms have different strengths. So some are better at research integration. Some are better at mathematical precision, and some are better at narrative drafting. Figure out which tool works better. If you have a couple at your disposal, try and see what happens. Test those results with each other. Because once you get this systemized for your own self, right, you can apply that to a broad base of clients, so long as you have those transcripts and their tax returns. And then finally, you have to file a separate Form 843 for each effective tax period. Okay. And a protective claim here only needs to identify the taxpayer, tax years, and your legal basis. You can supplement with detailed computations later if you're having issues. The important thing is to get the claim on file before that deadline of, and everyone should be singing it with me, July 10th, 2026. That's your deadline. Next slide, please. And this is, kind of a collection due process for those clients who are in active collection, meaning they've received a notice of federal tax lien or a notice of intent to levy, right? There's a powerful due lane strategy here through the collection due process proceedings. Lane 1 is the underlying liability challenge under section 6330C2B, right? This is available if the taxpayer had no prior opportunity to dispute the liability, meaning there was no notice of deficiency was issued and no prior hearing was held. The argument here is to frame the section 7508D interest and penalties as a liability computational error. The assessed balance on the taxpayer account includes amounts that Congress commanded shall be disregarded. Those are the key words. That makes the assessment itself incorrect. Lane 2 is the interest abatement request. This is not a challenge to the underlying liability, so the prior opportunity restriction does not apply. IRS Appeals' own CDP guidance found in IRM 8.22.8.2.2 recognizes both Section 6404 and Section 7508 Cap A, A2 as valid interest abatement authorities. So if appeals denies the abatement, the notice of final determination opens up tax court review under Section 6404H. So the strategy is to raise both lanes simultaneously where the facts permit. This will preserve all arguments on appeal, regardless of which lane succeeds. And critically, Section 6404H does not cap 7508 Cap AD relief. It is a jurisdictional provision, not a substantive limitation. Next slide, please. All right, what happens when a form previous one. There we go. That's fine here. All right, let me walk you through the roadmap. When this 843 is denied, right? When the IRS denies a refund claims, it's going to issue a letter 105C, which is a formal claim disallowance. From that letter, the taxpayer has two paths. Path 1, you have 30 days from the date of that letter to file a written protest to IRS appeals. This is an administrative appeal, and it gives you the opportunity to make your case to an appeals officer who may be more receptive to the Abdo and Kwong arguments than the initial processing unit. You'll present the legal authorities, basically everything we've talked about today, walk through the computations, which you'll have based on the transcripts, and explain why the mandatory suspension applies. Path 2, right? If you don't go to appeals, the taxpayer has 2 years from the date of the 105C letter to file a refund suit in either the United States Court of Federal Claims or an appropriate United States District Court under Section 6532A. This is the litigation option, and is why you're preserving the administration. And this is why preserving the administration claim is so important. You cannot get to court without first filing that Form 843. So I guess the strategic picture here is we expect widespread initial denials. That's not a reason to stop. It's a reason to keep going. Every denial letter generates a case. Every case that goes to appeal and every case that gets filed in court adds the volume that IRS management must contend with. Again, Taxpayer Advocate Service has already identified this as a problem, and building a broad base of filed claims and staying coordinated is what will ultimately force the IRS to address this issue on a global basis. And that's where we'll have some real power. So if we have 1,000 claims sitting in appeals or pending in courts, the IRS will have a problem it must resolve. So I guess to last slide 33, let me bring this all together. The bottom line, there is a sound legal basis. Next slide.
34.
Yeah, this is the last. There's a sound legal basis. It's gray laid out, confirmed by two federal courts in two different judicial systems for applying Section 7508 Cap A, disregarding period, to interest and penalties for late filing and late payment during the COVID-19 disaster period of January 20th, 2020 through July 10th, 2023. There is not likely to be any final word on this matter for years, okay? Appeals may be taken from Kwong. New cases are being filed, including the Fleischer class action for overpayment interest. The law will continue to develop. So again, remember, the deadline to file administrative claims is July 10th, 2026. That is a hard stop. After that date, the statute of limitations is gone and the claims are gone forever. So better be safe than sorry. File your claims, file them now. If you need any assistance, give us a call, get Frank Agostino's letter, and make sure you advance all the rights you can for as many clients as you can possibly find. And I'll pause there sharply at 1 o'clock. Gray, any concluding thoughts?
Thank you.
Yeah, no, Andy, thanks very much. No, that's everything I had. We might have time for a couple of the questions that are in the Q&A, or are we hard off at 1 o'clock, Andrea?
We can go a little over, but there's 3 questions if you can just maybe pick one or two that you'd like to answer.
Well, Andy, so Patricia Carbone asks this one. If we already filed a Form 843 for a penalty abatement or refund claim, should we file another Form 843 for the protective interest claim?
That's what I'm doing. I've done that I had a pretty, this was an individual taxpayer, and it was a penalty that we disagreed with the penalty, but I hadn't included in that the claim under Kwong or Abdo. So I submitted a different filing. I'll just say this: the IRS it's a disaster right now. I mean, the post-election, people leaving. I see them missing deadlines, getting computations wrong, saying things have happened that haven't. So it's literally, you have to build your case file piece by piece. So I don't see any downside in filing an additional claim. If anything, it gives you more authority to continue to proceed, and another option if something goes wrong. So it's a little bit more work, but using this guideline that we've put out there, once you kind of get it down, it should be simple. So I would definitely file that additional claim.
Thanks, Andrew. And then just quickly, Michael Lampert has asked, now that this is being coordinated nationally, he's trying to decide whether to go to trial on the issue. But what do we know about the national coordination? Last I heard, the IRS was going to fight all of these, but day to day, we don't always know what's going to happen. You have any insight?
No, I think that's great. Where we are right now is the IRS is going to continue to fight these. They're going to continue to get it wrong. And so, on these interest claims, I'm interested, and we already have, we're, hundreds of potential taxpayers. There is going to be power in numbers. So advancing claims to litigation, then ultimately you can bind cases. What we've been very effective at recently in the CE space is binding, similar cases together. And here we're talking about a commonality of law, right? And this is what will bind, and that's what becomes more powerful. So, step one, get all those claims in. Whatever clients you have, figure it out, get those claims in, because this is money to earn back for your clients or to prevent them from having to pay. Step two, we expect this to be contentious. We expect this to go to litigation one way or the other. How or if this gets impacted at higher levels, and we've already just started discussions at high levels with IRS management, remains to be seen, because all I can say right now is, leadership is a bit disjointed. These types of issues, right? There will be more attention with more numbers. So step one, let's get these numbers up.
Well, a huge thank you to Gray and Andy for sharing their expertise today. Don't forget to join us for the next CLE on April 29th. The course number is 9717 for those of you who missed it. And as a reminder, a recording of this session will be uploaded online. Thank you so much for your time today. I really appreciate Andy, Gray.
Yeah. And if anything, feel free to reach out to us. The more we coordinate on these issues, the more power we will have on behalf of our clients.
Absolutely.
Great opportunity that everyone should take advantage of.
Alrighty. Well, thank you, everyone. Have a great day.
Thank you.